Lords, I dealt with Article 11, which was one of the two provisions that the learned judge relied upon in finding in the context of the European backdrop, that under the European regulation there was no prohibition on judgments. Can I move next to Article 7.2c, which is the second of those provisions? Your Lordships will find that at Volume 1, even in your volumes, Tab 2, page 18. If I can just read 7.2, the whole of. Article 2.2 shall not apply to the addition to frozen accounts of interest or other earnings on those accounts. And then B, payments due under contracts, agreements or obligations that were concluded or arose before the date on which the natural or legal person, entity or body, etc. had been included in Annex 1, so when they became a sanctioned person. And then C, payments due under judicial, administrative or arbitral decisions rendered in a member state or enforceable in the member state concerned. Now, as your Lordships can see, just looking at 7.2c, which is primarily the focus here, that is a provision which deals with satisfaction or enforcement and not the entry of judgment. It's payments due under judicial decisions, etc., rendered in a member state. Provides that satisfaction of a judgment is not prohibited. But as your Lordships will have picked up, although this isn't concerned with the entry of a judgment, the learned judge considered that it was implicit in Article 7.2c that the entry of judgment in favour of a designated person was not precluded. So you've got a provision which on the face deals with satisfaction of judgments, and the learned judge effectively concludes that it's necessarily implied from that, that under this regulation the entry of judgment is also not precluded. And that is at paragraphs 29 and 36 of the judgment. I'm going to take your Lordships to it, pages 152 and 153. Now, my Lords, we respectfully submit that the learned judge was wrong about this. The primary reason is this. As I've noted, Article 7.2c is concerned with satisfaction, not entry. It does not say that the entry of judgments is lawful. The argument made by my learned friend and appears to have been accepted by the learned judge, therefore, as I say, depends upon an implication they seek to draw from 7.2c, namely that if satisfaction of a judgment is permitted, that necessarily means or assumes that the entry of a judgment is not unlawful and is also permitted. So this all depends upon showing that the implication or necessary implication of Article 7.2c is that the entry of a post-designation judgment is lawful. Now, my Lords, we submit this is not, in fact, what Article 7.2c implies at all, and that the learned judge's analysis was wrong. The main point we have about this, I'm going to focus on our main point, is that the implication for which my learned friends contend is actually inconsistent, certainly in the result it produces, with Article 7.2b. Can I just ask your Lordships to go back to that provision? So, Article 2.2 shall not apply to the addition to frozen accounts of payments due under contracts, agreements, or obligations that were concluded or arose before the date on which the natural or legal person, etc., had been included in the list. So Article 7.2b contains an express temporal restriction which makes it clear that it only applies to pre-designation obligations. So because the payment is due under a contract, etc., that were concluded or arose before the date of designation. And it is, we would respectfully submit, implicit in this, that post-designation obligations may not be satisfied.
We're dealing with pre-designation obligations.
We are, well, in a sense, the obligation is pre-designation, but we are not talking about.
Just simplify the point for a moment to test the argument. Assume that your clients are liable to the claimants
Yeah.
for breach of contract. An obligation that arose before sanctions, so that the obligation to pay under the contract, let's say, for the sake of argument, is covered by 7.2b. Assuming there's payment due under the contract, it's covered by 7.2b.
So far, so good.
If you don't pay, and they'd be lucky enough to get a judgment against you before sanctions, then it's covered by 7.2c.
That is the argument that is made.
Well, that's what it says, isn't it?
Well,
It's payment due under a judicial decision,
yeah.
rendered in a member state. That doesn't have a temporal restriction. But the effect of your argument is that whilst there's an obligation to pay, and if they've been lucky enough to get a judgment, then they can pursue the judgment. What they can't do is to commence proceedings and proceed to judgment.
With respect,
Seems
my lord,
pretty odd, frankly.
well, with respect, what your lordship makes, in a sense, proves too much. Because this is about payment, this is about satisfaction. So on your lordship's interpretation of what this means, one could not only get a judgment, but it could be satisfied in favour of a designated person. Now, no one, not my learned friends, certainly not the court, as I understand it, considers that there could be satisfaction in this country of a judgment.
Well, as far as Article 7 is concerned, provided the proceeds are frozen. So not satisfied in the sense of payment to the designated person, but you can credit the bank account and so on and so forth. So it's not quite saying satisfy in the sense you're there using it, is it?
In my respectful submission, it means you're satisfying it by paying it. You're paying into court, but you're still satisfying it. Can I just develop the argument that we make about the learned judge's conclusion, and really whether it is implicit in 7.2c that under this provision you could get a post-designation judgment under the EU regulations. We respectfully submit that that would be, as I say, inconsistent with 7.2b for the following reason. Your Lordship sees that under 7.2b there is a temporal restriction, which means that in respect of pre-designation obligations you can pay, but it doesn't extend to post-designation obligations, because it only applies to pre-designation obligations. Now, let's assume a situation in which there is a pre-designation obligation. That would be fine, you could pay it under 7.2b, no problem. Now assume a situation in which you could have a post-designation obligation. Payment of a post-designation obligation would not be permitted under 7.2b. If the learned judge is right about 7.2c, you couldn't pay the post-designation obligation under 7.2b, but if you sued the counterparty, who you couldn't make pay under 7.2b, you could get a judgment, post-designation judgment, against that party, and that would be payable under 7.2c. In other words, something which you're not allowed to perform because you can't perform a payment obligation post-designation, well, that doesn't matter because you just go and get a judgment against them, and the judgment you can get paid post-designation, even though it's a post-designation obligation. But the implication that the learned judge drew from this is that you could get a post-designation judgment. I'm going to try it again. The problem about that is that we said that's not the implication you should draw from this, because it undermines 7.2b, because it would enable you, in relation to a post-designation obligation, for which you couldn't get payment under 7.2b, to proceed, get a judgment, and you could get a court judgment in respect of the same post-designation obligation. Now, all I'm trying to establish at the moment is you can't imply anything into 7.2c, which is about satisfaction, about whether or not you can get a post-designation judgment.
Would C add anything on your case?
Would C add anything? Yes, it would, because it's true that it doesn't have a temporal designation. So it would still be there for pre-designation judgments.
But would that not be an obligation?
Well, no,
in
because
designation anyway.
with respect, this is all about circumstances in which you could. We're dealing with exceptions to Article 2.1 and 2.2. They are a prohibition on putting funds into the hands of designated persons. So what we have, so the focus here is on providing funds. The fund here is the judgment debt. Okay. If this is about satisfaction, so it's something which happens subsequently to that. What on our submission, what we're saying is to interpret this in the way that we suggest does add to what we're talking about here. When you enforce a judgment debt, you're not enforcing under B.
But you could be. I mean, suppose you just left out C.
With respect, you couldn't be, because you're enforcing the judgment debt.
Why would that not be a payment due under an obligation that arose before the date of designation?
Sorry, you got a judgment because there was a payment due under an obligation, whenever it fell.
But once you've got the judgment, there is a payment due under the judgment.
It's under the judgment.
So
In
why
other
isn't
words-
that in B?
Because that's not a payment due under a contract, it's a payment due under the judgment.
Due under contracts, agreements, or obligations. So it's due under the judgment, which is an obligation.
Because this is, with respect, he's talking about between the parties rather than, it's plainly not talking about judicial decisions, because judicial decisions is dealt with in C.
But if you'd left out C, you just said payments due under obligations that arose before the date of the designation. Wouldn't
Yeah.
you say, well, that's all right, it's a pre-designation judgment, the obligation's there.
So the judgment, I see, sorry, maybe at cross purposes. The judge, this is, so B is pre-designation obligations. The judgment wouldn't be pre-designation. The judgment would be post-designation.
And you say that's not good enough.
Well, that wouldn't be an obligation which was pre-designation, so it wouldn't fall into 7.2b.
But you're saying you can't infer from C that you can have post-designation judgments.
You can't infer from C that you can have post-designation judgments.
So C has to be read as applying only to pre-designation judgments.
All post-designation judgments which don't fall within 2.1 and sorry, post-designation judgments which have arisen, for example, because the court wasn't aware that the person was a sanctioned party. Primarily, yes. Primarily, it would be for pre-designation judgments. But there may be other judgments which exist because they came into existence when they shouldn't have. And this allows the enforcement of those judgments which exist, but shouldn't have, even though they're post-designation.
No, I follow the way you put that there. Just to be clear, is that the only circumstance in which C would add anything? Suppose that everybody knew that there was designation. You say, well, you're not within C. Pre-designation, you could just rely on B, you wouldn't need C.
With respect, your lordship may be right, but in my respectful submission, can I just put the counter-argument? That where it in B, it's talking about due under contracts, agreements, or obligations, it's not talking about obligations arising by virtue of a decision, because that is dealt with under C. So it's dealing with the underlying obligations which exist between parties, which you may want to make a payment under. A and B enter into a contract, A owes B money because of some non-contractual obligation. It's allowed to make the payment as long as the obligation arose pre-designation. C is dealing with the ability to make a payment under a judgment, in respect of a judgment debt. I suppose what I'm submitting is that, I don't think this is a necessary part of my argument, but in my respectful submission, the proper interpretation of this is that contracts, agreements, or obligations, the or obligations there, is an obligation that arises in a sense separately from the court's decision. So again, if I can try my argument again, can you imply from C that it envisages that you can, is it a necessary implication of C that you can obtain a post-designation judgment? Because this would allow the satisfaction of the judgment. Yes, in a particular way, but it would allow the satisfaction of the judgment. In our respectful submission, no. And we bring that out by the example I give your lordships, where you have a post-designation obligation. I'm going to call it a contract, so as not to confuse obligation. Post-designation contract, which, certainly on the face of B, you're not allowed to pay under, because it's not pre-designation, and B only works for pre-designation. But that doesn't matter, because you can go and get a judgment post-designation and satisfy it. In other words, the implication that the judge seems to draws from C is inconsistent, or produces a result which is inconsistent with the express terms of B. And in our respectful submission, that is therefore not an implication which one can or should draw from 7 to C.
Right.
The second point we make about this is this. I've referred your lordships already to the EU guidance indicating that the assignment of a cause of action is a prohibited dealing under EU law. If that is what the legislature intended, as it plainly did, we submit that it's very unlikely that at the same time the EU legislature intended that it should be permissible for the designated person to monetize the cause of action in other ways, for example, by obtaining a judgment. At the very least, it militates against the implication the learned friends seek to derive from Article 72C. Now, just to be clear on what I am contending and what I'm not contending, it's not my submission that this shows that my overall contention is correct. I'm not relying on this to establish that the court cannot enter judgment post-designation. I am simply seeking to meet a case that was made against me, that it is clear under the EU regulations that the opposite is the position. So all I'm doing is seeking to contend that, contrary to what the learned judge found, it is not clear from the regulation that under the EU disposition, if I can put it like that, you could get a post-designation judgment. Because if I'm right about that, then the continuity point that the learned judge relied upon doesn't work. And so I only need to go so far, not to prove that I am right, that this establishes that you can't get a judgment, but simply that it doesn't establish as a matter of necessary implication the opposite. And that's why I put the point as being, well, that would be a result inconsistent with 7.2b.
Yeah.
So you can't draw that inference. Now, the fact, as I say, you can't monetize in another way is another reason why we submit you cannot draw the inference. And I've sort of explained to your lordship why we say 7.2c was there and what purpose it serves anyway. Now, the other point we make about 7.2c is this. The learned judge, sorry, the other point to make is this. 7.2c was not transposed into the English legislation at all. In other words, whether or not 72C was a part of EU law, it's certainly not a part of UK law, because it wasn't carried across into the UK statutes. And in that respect, even if the judge was right about the implication, we respectfully submit it doesn't go anywhere. The UK, we submit, made a clear, conscious decision not to transpose that provision after Brexit. Can I, again, your lordships have in mind 72B and 72C and what they deal with. Can I now invite your lordships just to look at what was transposed? If your lordships can go to Regulation 58 of the 29 regulations, so AB, volume 1, for your lordships as well, tab 2, page 18. Sorry, that is the wrong
That
reference.
must be about.
It's AB, volume 2, tab 16, page 995.
Yeah.
Your lordship should have their regulation 58. Just looking at regulation 58.5. If your lordships look at regulation 58.3, you will see something which is the equivalent of 7.2a. We didn't look at 7.2a, but 58.3 is the equivalent of 7.2a. If you look at regulation subparagraph 5, the prohibitions in regulations 12 and 13 are not contravened by the transfer of funds to a relative institution for crediting to an account held or controlled, etc., by a designated person, where those funds are transferred in discharge of an obligation which arose before the date on which the person became a designated person. And that, as your lordships will spot, is regulation 7.2b, the pre-existing obligations exception. My lords, it is common ground that there is no provision corresponding to 7.2c. And that is no coincidence. In fact, a number of UK regulations prior to Brexit included 7.2c, and in all of them, 7.2c post-Brexit was taken out. Can I just give your lordships reference to this rather than turning it up? Article 8.1c of the Cyber Attacks Regulation 2019, volume volume 3 for your lordships, tab 7, page 716. That did contain the 7.2c exception, Article 8.1c. If you compare that to the post-Brexit regulation, which is Regulation 18, subparagraph 5, of the Cyber Sanctions EU Exit Regulations 2020, which is in volume 3 for your lordships, tab 6, page 692, that has been omitted. And if your lordship want to see an easy guide to this, can I invite your lordships to look at a table that the UK Finance produced, which identifies where this has happened. It's in volume, your lordship 2, tab 19, page 1522. Tab 19, 1522.
Give me the page number again.
1522, I'm sorry, that's where it begins, tab 19, 1522. The relevant references, if your lordships go to 1530, paragraph 4, top of the page, paragraph 4, exceptions and licenses, finance exceptions from prohibition. The exception under the EU regulation allowing a person to credit a frozen account with payments due under judicial, administrative, or arbitral decisions rendered in the EU or enforceable in the EU member states concerned without contravening the prohibitions on making funds available to or for the benefit of a designated person has been deleted. If your lordships go to 1548, this is dealing with the Burma sanctions regulations. This identifies the regulation 72C, and if your lordships then go on to page 1563, again, your lordships see reference to the fact that this is in the Burundi ones, that has been deleted as well. Now, it was deleted in the following regulations, just by way of examples. The CAR, the chemical weapons, the Democratic Republic of Congo, Nicaragua, and Russia. And just to give your lordships reference to that, pages 1574, 1653, 1825, and 1861. I'm not going to take your lordships through to them, because they all say exactly the same thing. That is only a very small sample of the point that 72C was deliberately taken out. Now, your lordships will have seen that the learned judge rejected our submission that 72C was taken out, or at least said that it was omitted because, in her view, it was unnecessary in view of regulation 58.5. That was her conclusion. We don't need that because of 58.5. And that is at paragraph 90 of the judgment. I'd like you to turn that up, page 166. Paragraph 990, page 166. Do not accept that the change of wording is the material help for which the defendant suggested is. What one sees when looking at the Act and the regulations, both overall and in the specific instance, is that this is not a case of replication of wording. The approach taken is different. The resulting documents are much longer, and there's a good deal of recasting. As for the provision for judgments, it might well be seen as coming within the new wording on the basis that whatever a judgment or award does, it effectively enforces an obligation which pre-existed. In other words, the changing wording can, at least on one view, be seen as a redrafting to remove redundancy, in that a judgment reflects an obligation. It might also reflect a discomfort with a provision which appears to trespass on the court's zone of operations, if it were the case that the legislators took the view that the making of a judgment would not in any event be caught by the regulations. Now, my lords, we respectfully submit that there are a number of reasons why the learned judge was wrong about this. We've touched on some of them, but if I can just go through them. First, if the learned judge is right, then a judgment may not only be entered in favour of a designated person, but can actually be satisfied even after designation, which is what paragraph 58 allows, and indeed satisfied without a license, because the exemption of 58.5 would be available. That is going, I think, further than the learned friends would go, because, and I say that because they say in their skeleton argument that a judgment cannot be satisfied after designation. And that's paragraph 13 of their skeleton argument, page 91. Secondly, regulation 58.5 refers to funds transferred in discharge of an obligation which arose before designation. But a payment under a court order made after designation is not transferred in discharge of a pre-designation obligation. For example, If following a 12-week trial in May 2025, my clients are ordered to pay something to the claimants, and they were to do so, they would be discharging the judgment debt. And that was a judgment debt that arose as a result of the order of the English court. They would not be discharging an obligation that arose prior to designation. Thirdly, and this goes back to a point that I think my Lord Justice Newey put to me, if the judge is right, then Article 7.2c was virtually redundant in the EU regulation, because most judgments could have been satisfied under Article 7.2b instead. Indeed, on the judge's approach, Article 7.2c would have been required only for obligations arising post-designation and culminating in judgments after designation. But that is not what Article 7.2c says. And your lordships have my submission that to permit Article 7.2c to be used in that situation, the only situation in which it would ever be needed on the judge's analysis would actually amount to circumvention of Article 7.2b. So on the judge's analysis, Article 7.2c would be redundant in every case except where it was needed to circumvent the temporal restriction in Article 7.2b.
I follow the way you put it. That does seem to lend some support to the idea that the EU regulation might give some separate meaning to C.
Indeed. And I accept that. That is my submission. Obligations is under 7.2b. It's not what 7.2c is being dealt with. And this is why we say it plainly hasn't been transposed by 58.5, which is about 7.2b. And so we say, with respect, the learned judge was wrong to think either that it had been or it didn't really matter. And if that's right, then 7.2c is not part of English law anyway. It's not part of the UK statute anyway. It's not clear where this gets the learned friends. Now, the fourth point we make about this is this. The learned judge's interpretation of Regulation 58.5 we submit is contrary to the reasoning of the court in the Modsaf case. I took your lordships to that case earlier. That was concerned with Article 11.38 of the EU regulation. What is significant for present purposes, my lords, is that it was common ground in that case that the actual payment of the arbitral award would have been unlawful. Indeed, the whole premise of the appeal was that it was unlawful to satisfy the arbitral award, which is why the question arose whether post-award interest, which accrued because the award could not be lawfully satisfied, was enforceable. And that, for your lordship's note, is recorded at paragraph 2 of my Lord Justice Newey's judgment. If I can just give you the reference. It's at volume 5, no, not volume 5, volume 11 for your lordships, tab 57, page 3460. And the fact that it was unlawful to pay the arbitral award necessarily implies that the equivalent of Regulation 58.5, which was Article 7.2b of the EU regulation, did not permit the satisfaction of the arbitral award, even though the underlying obligation which the award was founded arose prior to the date of designation. And so we respectfully submit for those reasons that the learned judge's analysis of Article 7.2c was wrong. There was no necessary implication about whether judgments could be entered post-designation. It was wrong about what Article 7.2c means, and it was also wrong in relation to the fact that whatever it meant as a matter of EU law, that provision was, we respectfully submit, deliberately left out of the post-Brexit UK regulations. And so we respectfully submit that for those reasons, the learned judge's reliance on EU law does not support her conclusion that the entry of judgment is lawful under the UK regulations. I should mention a last point. I think the learned judge said there was nothing in the regulations which said it was unlawful to enter into judgment. But equally, there was nothing which said it wasn't unlawful. And in our respectful submission, analysis of Article 2.1 and 2.2 make it unlawful, because because if there's no exception to that, it's caught within 2122 for reasons I've been submitting to your lordships. So, we respectfully submit that the European backdrop makes no difference to the proper interpretation of the UK regulations. Can I then move on to the next of the issues that arise, which is the principle of legality? For your lordship's notes, we addressed this at paragraph 54 of our skeleton and following. That's at CB tab 4, page 55. Now, can I make clear at the very beginning that, as we made clear in our skeleton, and indeed as we did before the learned judge, we accept that there is a principle in English law that certain fundamental common law rights will not be treated as curtailed unless this is clearly authorized by primary legislation. There is a principle in English law that certain fundamental common law rights will not be treated as curtailed unless this is clearly authorized by primary legislation. And that is how Lord Reed put it in the Unison case, which I'll take your lordships to. We also accept, my lords, that the right of access to the courts is one of those fundamental common law rights. As your lordships will have picked up, the dispute between the parties is about the scope of the right of access to the courts. And that dispute, my lords, raises a question of law, which I'll need to address, namely, what is the scope of the right of access to justice at common law? And as your lordships will appreciate, unless the particular step that we contend is prohibited by the regulations, namely the entry of judgment in favour of the designated person, need a temporary delay in the entry of a judgment in favour of the person, would constitute an infringement of the right of access, it would follow that the principle of legality is actually irrelevant and the statute would fall to be construed in the usual way. So if the backcloth here does not involve an infringement of the right of access, then since the principle of legality doesn't apply and affect your lordship's interpretation, your lordship can simply give the words the natural and ordinary meaning viewed in context, having regard to purpose, etc. We also submit, my lords, that even if the principle of legality is engaged, it is a principle of construction. It is not a rule of law with which Parliament is obliged to comply. Put differently, it is a presumption about what Parliament is likely to have intended. And as Lord Phillips put it in the Ahmed case, I'll give you a reference to that now, the principle, like any principle of construction, does not permit the court to disregard an unambiguous expression of Parliament's intention. That was Lord Phillips's observation, paragraph 117 of Ahmed, which is volume 7 for your lordships, tab 21, page 2219, between E and F.
Do you want to look at that?
I'm not sure your lordship needs to look at it, but I'm very happy to go to that if your lordships want to. It's at tab 21, like I said, volume 7, page 2219, paragraph 117. it's really Lordship sees paragraph 117. The other members of the House did not have a purported apart from wording that was clear and unambiguous. I do not consider that the principle of legality permits a court to disregard an unambiguous expression of Parliament's intention. To this extent, it reaches less than that of Section 3 of the HRA. That's an important point that I'm going to come on to. This is very different, for example, to Article 6. It is because, unlike Article 6, this is a principle of interpretation. It doesn't enable one to read in language. It's simply an approach, a presumption, a rule of construction, which arises if the right of access is hindered or impeded, because you presume Parliament didn't intend to do that without clear expression. So, now, as your Lordships will have seen from our skeleton, we submit that there are 4 separate reasons why the principle of legality is not engaged in the present case, and a further reason why, even if it is engaged, it does not affect the construction of the regulations. Your Lordships note these points are all addressed in our skeleton between paragraphs 56 to 66, that's at page 55 and following. I'm going to take them in a different order to the order in the skeleton, if I may. So from paragraph 56 to 66. The first of the 4 points I'm going to deal with concerns the temporary nature of the sanctions regime. And this point arises in the following way. If we are otherwise right about the construction interpretation issues that I've already addressed, then it is unlawful to enter judgment in favour of a designated person, subject, however, to the question whether a prohibition on the entry of judgment constitutes an infringement of the common law right of access to the courts, and subject obviously to the court point. I haven't forgotten that. So it's an infringement subject to the question whether a prohibition on the entry of judgment constitutes an infringement on the common law right of access to the courts, such that the principle of legality is engaged. We will be submitting, or we do submit, that it is not engaged, and I'll come to that point in a moment. But it is, we submit, important to be clear that the particular question that arises for your Lordships is not merely whether a prohibition per se on obtaining judgments infringes the common law right of access, but rather whether a temporary prohibition on obtaining judgment infringes it. Because that's all we're talking about. We're not saying the court cannot enter judgment. We're saying it cannot enter judgment for the temporary period of time during which sanctions exist.
Well, it may be better to describe it as indefinite rather than temporary, because it may last forever.
Well, with respect, your Lordship is right, but with respect, not quite right, because the question is whether, when you look at this statute, which was intended to introduce temporary, your Lordship's right, they are not defined terms, but they're certainly intended to be temporary. That's why it's not a confiscation. A temporary prohibition on doing certain things. So I want to emphasize temporary. Your Lordship's right, there is no defined date. But whether or not there's a defined date, this is not an expropriation of rights. This is not taking away rights. This is not an extinguishing of rights. This is not saying to the court you can never do this. This is simply saying, for a period of time while sanctions are in effect, you cannot do this. And in our respectful submission, that matters. And I accept there's no definite period. And we say this matters because having regard, and in a sense this is repeating the point I've just made, having regard to the nature of sanctions, any prohibition is designed to be temporary, even if potentially prolonged and even if potentially indefinite, because sanctions are inherently designed to be temporary, which is why they constitute a restriction on the right to use assets, but are not an expropriation of assets. And for your Lordship's notes, the explanatory note to the 2018 Act says expressly that sanctions are restrictive measures which are designed to be temporary. I'm using the language of the explanatory notes there, which are designed to be temporary. That's at paragraph 4, and that is at volume 3 for your Lordships, tab 12, page 845. And we submit that a temporary, as distinct from a permanent restriction on the ability to obtain a money judgment is plainly not an infringement on the common law right of access to justice and does not engage the principle of legality. I'm going to be clear with your lordships, we'll come to it. Under Article 6 it is a problem, but Article 6 is very different. One of the difference between the two, as your lordship will appreciate, is that Article 6 is not an absolute right. It only matters if the restriction is unjustified. That's to say, if it is not done for a legitimate purpose or is disproportionate. None of that applies with the right of access. That's why one has to be very careful with the right of access. It is an absolute right. It's not flexible in the way that Article 6 is. There is another difference between the two, which I'll come on to when we go to Article 6, but it's this. The right of access, as I say, is a principle of interpretation. It doesn't enable you to read words in. And that's the point made by Philip Sales, Lord Sales, as he was in the note that your lordship will see us having referred to. That's different to Article 6, which does enable you to read words in. There's a prohibition. So just getting back to our point about temporary restriction, we submit that a temporary restriction, as distinct from a permanent restriction on the ability to obtain a money judgment, is not an infringement of the common law right of access to justice, and it doesn't engage the principle of legality. There are, of course, as your lordships will know, all sorts of temporary restrictions on the right to obtain a judgment debt, many of which are imposed by the court itself, such as a case management stay to facilitate mediation, or to await the resolution of related foreign proceedings, or for any other reason. Some of those will be indefinite in duration as well, but they're all intended to be temporary. And my lords, a temporary restriction of that kind, we would submit, plainly does not infringe the common law right of access to the court.
Well, speaking for myself, I would find it slightly surprising if a provision which said you can't pursue your cause of action for 30 years wasn't regarded as one which infringed the common law right of access, although it's only temporary and it's only for 30 years.
Well, my lord, I can see that. And I can see that, but we're not in that world.
Well, it might be. We don't know, do we? It's indefinite. I mean, some of those sanctions regulations which were renewed, as it were, by post-Brexit, go back quite a long way.
Let me start from the other end.
Iran, for example, has been enforced for a very long time, in one way or another.
Let me start from the other end. Case management stay, for example, because there are proceedings abroad, which may delay proceedings here and will certainly delay a judgment here. We submit plainly isn't a restriction on the right of access to the court. In fact, what has happened is you've come before the court and the court has said, I'm not dealing with this until something else happens. And they've imposed a temporary stay. In our respectful submission, that is not a restriction, that is not an infringement of the right of access to the court. Because the court has made a decision as to what to do with you. If that is right,
when the court makes that decision, it will bear in mind that the argument that there might be a restriction on the right of access to the court. So that's part of the balancing exercise in determining whether or not to impose a case management stay.
my lord, can I?
Case management stays are pretty, I mean, okay, you can stay the proceedings pending mediation, agreed, as part of the normal process of business and property court litigation, but it's a slightly different creature with respect. What it's really doing is saying, as part of the procedure, we build in mediation.
Can I respectfully
if you choose to
suggest?
mediate, you don't have to.
can I respectfully suggest that your lordships get to the result you want to get to by virtue of Article 6.1, by virtue of Article 6 of the European Convention of Human Rights, because that plainly does apply to temporary delays. And where it bites is where the delay has become inordinate or undue. And that you don't need to convert a right of access to the court, which is, in our respectful submission, much more limited in its ambition, into something greater. Because you don't have the problem that your lordships are identifying over a 30-year period, but you don't have it because Article 6, whatever the equivalent is, doesn't allow that to happen. And it will stop that happening at the point in time where the delay becomes undue. But in our respectful submission, that is not the work which is done by a right of access. Yeah. And can I perhaps just identify what we respectfully submit is a fairly straightforward way of demonstrating that the principle of legality is not engaged by a temporary restriction on the ability to obtain a judgment debt, such as a case management stay. And it is this: if, as my learned friends contend, such a restriction does engage the principle of legality, then it would follow that the court would have no power to impose a case management stay unless the exercise of this power was clearly authorized by primary legislation, not merely by the CPR, which is not primary legislation, but by an act of parliament. Because that is how the principle of legality would work. It would say, unless you have a statute which clearly gives you the power, you don't have the power. Now, the problem about this from my learned friend's point of view, let me just add a bit, and I say that, my lord, because it's common ground that where the principle of legality is engaged, the infringement of the relevant common law right must be clearly authorized by primary legislation. But the courts, of course, have an inherent jurisdiction to grant a stay, which does not depend for its existence on any statute. And the courts have exercised that inherent jurisdiction for centuries. Now, can I, without going to the authorities, just give your lordship some reference to those authorities for that proposition? The proposition that the power to grant a stay arises out of inherent jurisdiction rather than out of some statute. The House of Lords in Rockware and McShannon, tab 89, page 4298 to 4530A in the speech of Lord Savin, and the Roffa case, ROFA, tab 90, which in your lordship's bundle is bundle 14, page 4553 D to G, in the judgment of Lord Justice Neal at the letters D to G. And third, the Grenfell case, which is bundle 10 for your lordships, tab 46, page 3132 B to C in the judgment of Lord Justice Ormerod. Now again, my lords, what those cases decide is that the court's jurisdiction to grant a stay did not derive from the Juridicature Act or the rules made under it, but arise from its inherent jurisdiction. And if the judge was right to say that a temporary stay infringes the common law right of access to justice, such that the principle of legality is engaged, then this inherent jurisdiction cannot exist, because the court would not have the power to grant a stay unless this is clearly authorized by primary legislation. And the very fact that this is not the law, and that the inherent jurisdiction has existed for centuries, we submit, shows that the learned judge was wrong to hold that paragraph 112, that a temporary stay on proceedings infringes the common law right of access to justice, such that the principle of legality is engaged. We say it is not.
Can I put something to you that's troubling me, which is that you're putting all temporary measures into one basket and saying either they must all infringe the common law principle of access to justice, or they can't, and you say they can't if they're temporary. This is, you say that there's clear recognition that some forms of delayed justice, temporary interruption are permissible without infringing the common law right. But do they all go into the same basket? I mean, if you adjourn a case for a day, you're delaying matters. That has the effect of a temporary delay. One wouldn't have thought that that was an interference with access to justice. If, on the other hand, a judge says, I'm going to adjourn this case for 25 years, you would think, well, that does. Now, you may say, well, no, not under the common law right, that's only an Article 6 point. You may persuade me on that, but I understand that aspect of it. But leave that to one side. Simply characterising something as temporary and using that to argue, and I think you are now, to say the principle of legality simply doesn't apply to anything which is temporary, never mind how temporary. It seems to me that it doesn't really engage with the reality of different kinds of temporary interruption in the judicial process.
Can I answer this in this way? I can quite see your Lordship's point that to have a statute which says you're not allowed to come to the court for 30 years is very likely to be regarded as a restriction of the right of access to court, because you're actually saying to someone you cannot come to court for 30 years. On the other extreme, I think your Lordship accepts that if it were the court saying, I'm not going to deal with this for a month, for 2 months, for 2 years, or even for a period which is indefinite, but not expected to be 30 years, that would be, at least conceivably, would not involve a restriction on the right of access to the court.
My point is, it might or might not, depending on the period and depending on all the circumstances.
It
but
might
certainly
or-
at one end of the scale, it certainly wouldn't be adjourning it for a week.
And my response to that is, yes, of course, if you have a statute which effectively says for 30 years you can't come to the court, you're not being allowed access to the court. You're never getting into the court's hands for a period of 30 years. That plainly would infringe the right of access, because at the very least, and this is how it was described by Lord Justice Laws, you ought to be able to get to the doors of the court. There should be nothing which restricts you from getting to the court. Once you're in the court, if the court says, I'm not going to hear this for a year because there's something happening in the United States, that is not a restriction of the right of access. If the court says, I'm not going to hear this for as long as sanctions are in force, it is conceivable, and in my respectful submission, that doesn't, again, in circumstances where you don't know how long sanctions are going to be. They may be long, but they may not be long. That in itself is not a restriction on the right of access. You may have a problem if after 5 years or 6 years, nothing has happened. You would certainly have a problem under Article 6. But you've been put into the hands of the court, and the court has made a decision. You haven't been denied a right of access to the court. You've been in the court's hands, and it's made a decision about it. So,
Well, I'm not sure I would accept that, which is my Lord's point, which is when that decision is taken by the court, it has to look into the future and see what the possibilities are. It may well be that if there's litigation elsewhere which may resolve the issues, either because it's between related parties or whatever, then actually that's not much of an interference with your right of access, because you'll get justice in an alternative way, just as in the same way as you will with mediation.
Yeah.
If, on the other hand, it's in a jurisdiction where that might not happen for 30 years and it might not resolve it, then you're saying, well, it's a judicial decision and you're in the hands of the court. That wouldn't necessarily answer the question as to whether it's an interference with the rights of access, would it?
well, I can't push back on that. I'm not going to push back on that, because I'm not going to.
Well, your primary case is that the right of access is simply a right to get to the door of the court.
And for the court to make a decision which
And
deals with,
that's it.
well, it goes a little bit further than that. The court, but by the doors of your court, if your lordship means you go before a judge and a judge decides what to do with your case, then in our respectful submission, the right of access as it's contemplated, which is to prevent you going to court and letting the court do anything about it, is not infringed. You're in the hands of the court. I've got a series of points on the right of access. I don't want
Just before you do, so you say you have to be allowed to go to the doors of the court and for the court then to make a decision. So if there were a statutory bar on issuing a claim at all, the principle of legality would be engaged. If on the other hand Parliament said not that, but that once proceedings have been issued, the judge must stay the proceedings for 30 years. You say the principle of legality is not infringed because it's got as far as the judge.
That would follow from our submission. Plainly, the judge could not do that because of Article 6. You'd have an Article 6 problem. So to some extent, your lordships are putting to me problems which in the real world won't arise because they will be dealt with under Article 6. They don't need the right of access, the common law right of access, to deal with them. And in our respectful
Well,
submission...
you may not need, you may be right about that, but what we're exploring is what the scope of the right of access is. And I think
accept that.
what we're suggesting to you is that it's not limited in the way in which you say it is, but you haven't really finished making your submission, so we don't yet know what the answer is.
My lords, as I say, we have 4 reasons why the right of access doesn't arise here. I'm on the first one, and I can see that's going down like a bag of sick. I'm not going to use all my time on that one. Your lordship has our points about that, and in our respectful submission, the right of access is limited. It's certainly, well, I'm not going to repeat my point.
Well, you say if it's a temporary restriction on the right of access, it's not a right.
It's not. You're not infringing the right.
You've got the point, Mr.
You've got the point. My learned friends identify a series of cases. I think there are 4 of them. In fact, 3 of them are only about Article 6. There's one which is about the right of access as well as Article 6. That's the Siddiqui case, but it really doesn't deal with the point that we're on now. Okay. And I'll let my learned friend develop those if he wants to. As I say, my lord, that is what we say about the first point. I'm not sure I can say anything else beyond that. Can I go on to the second reason, which we'll see how this one goes. It's the one we've called the Bellhush point. And we deal with this at paragraph 56 of our skeleton. That begins at page 55. And this arises out of a point that Lord Sumption made in that case, which your lordships have at tab 69, which is in volume 13 of your lordships bundles, page 3993. And I invite your lordship to go to that. Just to say something about the facts of this case, to put it into some context. The issue in Bellhush was whether the closed material procedure was available in certain judicial review proceedings. The claimant in Bellhush had challenged the decision of the DPP not to prosecute certain individuals. And the Secretary of State had sought to use the closed material procedure in defending the judicial review claim, and the claimant had resisted it. So the issue was, do particular judicial review proceedings fall within or without the category of claims for which closed material procedure was appropriate. And whether the closed material procedure was available depended upon the construction of a particular statute, namely the Justice and Security Act 2013. That act authorized the closed material procedure in relevant civil proceedings. So the phrase was in relevant civil proceedings, and that was defined in section 611. Your lordships will see that quoted at paragraph 8 of Lord Sumption's judgment, which is page 4028. Just after section 6. Relevant civil proceedings, just below the quote. Relevant civil proceedings are defined by section 611 as any proceedings other than proceedings in a criminal cause or matter before certain bodies. So proceedings other than in a criminal cause or matter. Now,
you can make an application for a closed material procedure in any proceedings. That's the point.
Yeah, and so the issue here was, were you dealing with proceedings in a criminal cause or matter? Because if you were, then it couldn't be relevant civil proceedings, and you couldn't get your CMP order.
No.
And the claimant argued that the principle of legality dictated that this phrase, proceedings in a criminal cause or matter, should be given the widest possible construction because the use of the criminal CMP infringed the fundamental common law right of open justice. And that contention was rejected by Lord Sumption, and if I can show you Lordship's paragraph 13 and 14 on bundle page 4030. Just picking it up, paragraph 13. Mr. Ben Jaffe QC, who appeared for the appellants, took it as his starting point that closed material procedure represents a curtailment of fundamental common law rights. Therefore, it was said, in accordance with the principle of legality, any statutory provision relied upon as authorising this should be given the narrowest possible construction. The principle is that general ambiguous words cannot normally be taken to authorise a curtailment of fundamental rights because there is too great a risk that the full implications of their unqualified meaning may have passed unnoticed in the democratic process. Parliament must squarely confront what it is doing and accept the political cost. Valuable as that principle is, I do not think it helps to resolve the question at issue in this appeal. The Justice and Security Act 2013 made significant and acknowledged inroads into the common law principle as applied to relevant civil proceedings. It did this subject to specific safeguards on the grounds that the interest of justice might well require the withholding of evidence from a party if the dispute cannot otherwise be tried fairly and consistently with the demands of national security. As the House of Lords held in Al Rawi, the existence and extent of the court's jurisdiction to adopt closed material procedure is a matter for Parliament. That involves a balance between the potentially conflicting interests of national security and justice, which Parliament has drawn in the Act of 2013 by authorising the procedure subject to the statutory safeguards. This leaves little scope for any presumption that Parliament does not intend to curtail fundamental common law rights. Parliament plainly did intend to curtail them in what it conceived to be a wider public interest. The only questions are on what conditions and in what proceedings. Those questions must be answered on ordinary principles of construction without presumptions in either directions. That's the Bellarge point. Now, we say, my lords, that the present case is another example of the point that Lord Sumption was making. And we say that, my lords, because it is evident on the face of the 2018 Act that it does indeed intend to curtail a fundamental common law right, namely the right to the peaceful enjoyment of property. And curtailing that right is, in a sense, the whole point of any sanctions regime. There may be a question about whether the extent to which it is curtailed is proportionate, but the fact that the legislature, which enacted a sanctioned legislation, intended to curtail or restrict the right to property cannot be seriously disputed. And of course, one of those restrictions imposed by Parliament on that right is that designated persons may not dispose of or otherwise deal in their assets. So, for example, they cannot sell their own house or use their own money to buy a car. And nobody can give them a car or a house. And my lords, it is the same restriction on dealing in one's property, making property available, that prevents a designated person from dealing in any causes of action he may have, for example, by signing it for money, which, as I think is common ground, would be unlawful without a license. In other words, converting an asset of one type, such as a cause of action, into an asset of another type is prohibited. And my lords, that being so, there can, following Lord Sumption, we suggest, be no scope or any presumption that Parliament did not intend to curtail the right to use or convert the same asset, cause of action, in a different way, namely by obtaining judgment debts. Now, I know what's on your Lordship's mind, and as your Lordship may recall, the judge distinguished Belhaj on the basis that there was in that case a derogation in the 2013 Act itself from the very right, that's to say open justice, in relation to which the principle of legality was invoked. Whereas in our case, the derogation in the 2018 Act from the right to property is being relied upon to displace the principle of legality in relation to a different right, namely the right of access to the courts. And your lordships will recall that is what you see. I'm not going to turn it up in paragraph 101 of the judgment. It's at page 168. And my lords, we have two responses to that. The first is that what the learned judge said at paragraph 101 misunderstands our submission. Our case was and is that obtaining a judgment debt constitutes a dealing in property, just like the assignment or settlement of a cause of action. They are all different ways of turning a cause of action into money. The only difference between them is that one involves the judicial process, whereas the other does not. But that does not detract from the fact that all three of them constitute a dealing in property, namely the cause of action or the judgment debt. And so, my lord, since it is apparent from the 2018 Act that Parliament plainly intended to restrict the right of property, for example, by assigning a cause of action, we say there can be no presumption that Parliament did not intend to restrict other ways of turning the cause of action into money.
I'm sorry to keep interrupting. You've several times talked about turning the cause of action to money and monetising. But how does the mere entry of a judgment monetise the cause of action? Surely you only monetise it if you then do something with the judgment.
Well, in our respect for submission, I mean, entry of into the judgment actually gives you a fund, because you can take a judgment debt and go to a country where there are no sanctions and change that for money.
Well, that's the moment at which you monetise it. But are you monetising it or turning it into money, as you were calling it, simply by obtaining the judgment at that moment?
No, you are I accept that you're not doing that. You're not doing that. But effectively, it is a restriction of property. And if this is an act about restrictions on your free use or enjoyment of property, or your ability to obtain property as well.
So you say it's all part and parcel of the curtailment of the fundamental right of peaceful enjoyment of property,
Precisely.
which this Act is clearly directed. So the judge's
Well,
grounded distinction is
She misunderstood our point, which is we're just saying there's no presumption either way. This is plainly an act which intends to interfere with your use and enjoyment of property. If no one would dispute, if everyone accepts that it'll interfere with your use and enjoyment or your ability to get property.
Well, I think the argument against you is what's involved in getting to the stage of simply obtaining the judgment is that you're not at that stage dealing in enjoyment or use of your property. You're engaged in determining your rights to property.
Well, let me put that slightly differently. Your Lordship puts it in that way. I put it in a slightly different way. What this Act plainly does is to stop anyone giving you property. It's plainly intended to stop you getting anything of value from anyone. And in that sense, it is plainly a prohibition on a fundamental right, which certainly some fundamental right. It's stopping you getting anything which absent this you would be able to get. So it's definitely an infringement on some right of yours. And the point we're making very broadly is if, as cannot be doubted, sanctions do that in some respects, why should there be a presumption against them doing it in some other respect, namely through getting the court to give it a judgment? That's the one way in which we put the point. This is plainly something which is intended to interfere with your fundamental rights. Why should there be a presumption that Parliament didn't intend to do that? And the way in which it's interfering with your fundamental rights here is very much in stopping you getting property, using property. This is just another aspect of getting property and using property. Why should there be a presumption against it being done in a particular way? We also
convenient moment to have a break.
my lord, if it's convenient for you, yes, it is. It's as convenient as...
No, I didn't want you, if you were, I deduced that you weren't in the middle of the forum.
It's a convenient point, my lord.
Good. All right, 5 minutes.
it just means you can bring it into any right. And that would mean
first point we make is, in light of following on from the Bell Hutchie point, and in circumstances where it's plain, this is a statute which is intended to inhibit certain fundamental rights. There should be no prohibition either way. Sorry, there is no presumption either way. You should simply look at the language. That is our first answer to what the judge said. The second answer is that, in fact, the 2018 Act does reveal on its face an intention to restrict the very right which the claimants say is implicated here, namely the right of access to the courts. Just by way of context, as your lordships will know, the Supreme Court in the Ahmed case quashed regulations made under Section 1 of the United Nations Act 1946 on the grounds that the restriction of the relevant common law right, that's the right of access to court, to challenge designation had not been clearly authorised by the 1946 Act. Your lordships note that is at paragraph 81 in the judgment of Lord Hope in Ahmed, and also at paragraph 124 in the judgment of Lord Phillips. Ahmed is at tab 21 page, and the relevant extracts I've given you are page 2210 and 2221. My lords, and by contrast, a similar challenge in the Yusuf case, YOUSSEF, to orders made this time under the 2018 Act, the one with which we are concerned, failed. And it failed precisely because it was clear from the 2018 Act that Parliament did intend to restrict the right of access to court to challenge designation. That was clear, the court found, in respect of the 2018 Act, because Parliament had provided an alternative statutory mechanism that was similar but not identical to ordinary judicial review. And your lordships will find Yusuf at tab 78, which in your lordships bundle is volume 13, page 4265. I invite your lordship to look at paragraph 61 and 62 of that authority, page 4279. Just picking this up at 61. As is apparent, it was critical to the decision of the majority that the 1946 Act, this is in Ahmed, did not either expressly or by necessary implication circumscribe the common law right of access to the court. The 2018 Act, by contrast, does just that. Section 1 empowers a minister to make sanctions regulations for the purposes of compliance with a UN obligation. The 2018 Act addresses the question of whether and when a designated person under the 2019 regulations can seek a remedy in the courts. Sections 25 and 38 provide a mechanism by which a person can seek review by a court of a decision by the Secretary of State not to comply with a request that she uses her best endeavours to secure his removal from the relevant list. It is implicit in that statutory scheme that the person has no other resort to the courts. In consequence, in my judgment, it cannot be said, as the claimant seeks to say, that the decision of the Supreme Court in Ahmed is dispositive of his present claim. The Supreme Court in Ahmed was addressing the common law position in the absence of an adequate statutory mandate. There is now a statutory scheme which covers the ground. Mr. Squire says that the 2018 Act is materially identical to that which was not regarded as sufficient by the Supreme Court. That is entirely to miss the point. In Ahmed, the court was concerned with the statutory provision, the 1946 Act, which could not be said to authorise restrictions on the common law right of access to the court. The 2018 Act does precisely that by introducing the sections 25 and 38 arrangements. Now, if your lordships can look, please, at the judgment. The judge dealt with this at paragraphs 102 and 103. That's at page 168 of the judgment.
The point here was that the claimant was seeking to challenge the scheme, the sanctions scheme, and the imposition of the asset freeze on the basis that it deprived him. Well, it was actually an Article 6 case, I think, wasn't it, rather than a fundamental right of access to the court.
I think there was also a fundamental right of access point.
But the point the judge is making in 61 is that is wrong because the Act expressly contemplates or expressly provides a procedure by which you can challenge the Secretary of State's decision.
Exactly.
But that's got nothing to do with whether or not the Act clearly deprives people of the fundamental right of access to the court in circumstances like the present case.
Your Lordship says there's nothing whatsoever to do. I accept that it is a different case because effectively it identifies two things. Number one, it's making clear that you necessary implication or by implication is clear. You don't need clear words.
Well, that's, I think, is common ground.
I think that is common ground. Number two, it is a situation in which the court, because Parliament has plainly confronted the question of right of access and provided a scheme, the judge says, well, I'm not going to read any. This is not like an Ahmed case where there was no right of access. They plainly hadn't thought about it. Therefore, I had to read it in a different way. Now, what we say here is two things. Number one, the first point, going back to fundamental rights generally, this is plainly a statute which is intended to impede fundamental rights of various kinds. So why would you make any assumption at all, or presumption, as to being able to access fundamental rights in one way rather than another? Whether or not you should be able to do that will should depend on the language of the regulation itself. Number two, as is clear from Yusuf, this is also an act in which there has been a restriction on the access to on access to justice, certainly in a different circumstances, but plainly, again, in circumstances where there has been knowingly a restriction of the right of access. Again, why would you draw a presumption one way or the other in relation to any other restriction of right of access? Parliament has shown in this Act it is willing to restrict a right of access. We don't say that it proves that it was not interested in access. We just say that there's no presumption either way. Because in circumstances where Parliament has shown that given the public interest in sanctions, it will restrict a right of access. And it has done so very clearly in one way.
Well, in relation to the challenge to
Indeed.
the sanctions.
I accept it was in relation
not
to...
in relation to whether or not the designated person can pursue
Your Lordship's completely right.
other common law rights.
Your Lordship is completely right. It has plainly shown a willingness to restrict a right of access in one particular way. It hasn't shown a willingness, or it hasn't said anything about restricting the right of access to justice in another way. The point that we make is this: in circumstances where it has shown a willingness to restrict a right of access in any way at all to justice, we submit no presumption should arise as to whether or not in any other respect it was wanted to or didn't want to restrict a right of access to the court. It may or it may not have done, but whether or not it has done depends upon the language used in the statute and the regulation, free of any presumptions, because presumptions cannot arise in circumstances where not only has the court shown a willingness to hinder generally fundamental rights, but it has also shown a willingness to hinder rights of access to the court. So again, I accept it's a right of access in a different context, but it is a willingness to restrict right of access or to impede right of access. And what follows from that, we say, again on the Belhaj type of analysis, is that we don't say from that it is clear therefore that the court intended to impede a right of access here. We say that no presumptions arise. Because in circumstances where it has shown a willingness to impede a right of access, you can't assume that it hasn't done so somewhere else or in another way. That's really the point we're making on this. So that is our second ground. There are, as I say, a general impeding of rights, fundamental rights, but also in relation to a right of access to the court. We don't say that means your Lordship should be happy that there is, in fact, an intention to impede access, but whether or not it is simply identified by construing the language of the statute without presumptions either way. Now, in their skeleton, the learned friends make a point in support of the judge's approach. This is at paragraph 37 of their skeleton. where in reliance on paragraph 80 of the Unison case, they say that a statutory power that authorises an intrusion on the right of access must be interpreted as authorising only such a degree of intrusion as is reasonably necessary to fulfil the objective of the provision. And my lords, there are two answers to that. First of all, Malone and Friends' submission begs the question. The principle identified in Unison applies, which is that you should interpret it only as in the narrowest ways in order to achieve the function of the statute. The principle identified in Unison only applies if the principle of legality is engaged. But that is the very issue that your lordships are seeking to determine. That is to say, at this stage of the analysis, is the principle of legality engaged or not? Is it displaced for the reasons given by Lord Sumption? Secondly, and in any event, your lordships have my submission about why it is necessary for the entry of judgment debts to be prohibited in order to achieve the objective of the sanctions regime. Otherwise, as I have submitted, terrorists or other sanctioned persons will be able to use the English courts to obtain a judgment that they can take elsewhere to enforce or otherwise turn to money, which is just exactly the opposite of what the sanctions regime seeks to achieve, namely to deprive them of any resources whatsoever. So if one were to interpret the 2018 Act in a way that the degree of intrusion was kept to the minimum to fulfill the objective of the provision, it would certainly still apply to deprive terrorists and other sanctioned persons of the ability to get a judgment debt, which we submit is little short of a cash equivalent. So, my lords, that's the Bellage point, and that's the second of our reasons why the principle of legality is irrelevant. The presumption is displaced. The third reason concerns the legislative history of the 2018 Act and the 2019 regulations. Now, as I submitted earlier, my lords, the reason why we submit that the entry of judgment is unlawful under that regime is that the 2018 Act contains or authorises a prohibition on first, dealing in funds and economic resources, and secondly, in making available funds and economic resources to designated persons. That language, funds, economic resources, dealing, and making available are, if you like, Lord Diplock's categories in Duport. But as we note, this is at paragraph 59 of our skeleton, those phrases, the phrases dealing, funds, economic resources, and making available, are not in any way peculiar to the 2018 Act. They are not in any way peculiar to English legislation. They are in fact drawn from the language of international sanctions regimes. And they have been since 1999, when the United Nations Security Council adopted Resolution 1267, from which the modern law derives the language of that international sanctions regime. All those phrases start around 1999, they carry through the EU regulations, and they're adopted in the English legislation. And so when Parliament enacted the 2018 Act, those expressions had already been used outside of this jurisdiction, as well as in, but outside as well as in, for some 2 decades. And my lords, it is, we submit, unlikely that in 2018, Parliament, when using those exact same words, intended something different from what they meant under the previous regimes, which, as I say, was very much not a UK-specific regime, and indeed not UK-specific legislation. We say this was unlikely, that in 2018 Parliament meant something different when it used those same words. Parliament used exactly the same terminology. seems unlikely that it intended something different. And so, my lords, on our case, that the entry of judgment would be unlawful is not one that turns on the construction of the 2018 Act in a vacuum. Rather, while our case does squarely raise the question what the words funds, economic resources, and making available in that statute mean, it is obviously material to note that those words, which Parliament has chosen to adopt without material change, come from UN resolutions and EU resolutions, in relation to which plainly the common law principle of legality would not be relevant. Because the common law principle of legality is a principle of the common law which applies to English legislation. It plainly doesn't apply to the interpretation of certainly United Nations statutes or to EU regulations. Now, my lord, the only reason the judge gave for rejecting the submission is that the usual principle of construction should apply, since the 2018 Act and the 2019 regulations are UK legislation, and that is at paragraph 98 of her judgment at page 167. And the learned judge has no hesitation in concluding that our argument is wrong because this is in UK legislation. And my lords, we respectfully entirely accept that we're dealing here with UK legislation. But what, with respect, the learned judge has overlooked is that the principle of legality is a principle of construction that is designed to identify what Parliament intended. And my lords, the points we are making is that the question before the judge was what Parliament intended, and that question arose not in this context in relation to language that Parliament had itself freshly minted, but rather the question was instead what Parliament intended when, no doubt deliberately, it used terminology that had appeared in United Nations and EU documents for some 20 years. And since, as I say, it seems unlikely that Parliament...
I can see the argument that because, or that deploys as part of your case that it is clear, even if it's not express, but it is clear by implication that the fundamental right of access to the court is removed by the statute because of the use of the same language as in UN resolutions and so forth. I have more difficulty in saying that it excludes completely the principle of legality in relation to an English statute.
So my lord, we obviously have, these are separate arguments in relation to the right to the principle of interpretation. The principle of interpretation is one of English law. The first one, temporary stays, I'm not going to repeat it, but that is, does the right of access prevent a temporary stay? That's the first one. The second one is the Belhage point, which says Parliament is intended to... This is a different point. This point is
the point that says there is the principle that you've actually have written down. The principle of legality is not applicable because this statute uses the same wording as the UN resolutions.
Can I try and put it in a different way then? Principle of legality is a principle for interpreting what Parliament, the English Parliament, did when it used particular words, which it chose to use. And you say it chose to use those words. When it chose to use those words, we're going to presume it didn't intend to hinder some fundamental right because if it wants to do so, it needs to do so clearly. Plainly, you do not adopt, one does not adopt a principle of legality when you're construing UN Security Council resolutions or EU regulations because they have a different constitutional setup and fundamental rights such as those and presumptions of interpretation to which those fundamental rights give rise are peculiarly English. I'm going to say peculiarly English, partly because I don't know what everyone else does, but I certainly don't understand the presumption, which is a common law presumption, to arise, for example, in EU or Security Council.
Something quite close to it may, whether you call it a rule of construction or a presumption or whatever. So far as the European use of those expressions is concerned, I would have thought, I may be wrong, that they would have failed to be interpreted so as to be Article 6 compliant.
I have no
Now, I
problem
know-
with Article 6.
Well,
I'm going to come
I
to
know you
Article
say
6.
there's a distinction between Article 6 and the common law, right, and you may have to show me a little bit more on that. But it's not self-evident to me that so far as parliamentary intention is concerned, and whether the principle of legality should or shouldn't have been one which you apply in the context of the UK legislation, that the fact that these have a defined meaning in European legislation which applies at least a very similar concept, if not an identical concept, means that the principle of legality simply goes out of the window.
Can
Have
I
expressed that sufficiently clearly for you to understand my
Your Lordship has
difficulty?
expressed that sufficiently clearly. In my respectful submission, at this point, it is necessary to look at Article 6 to understand why Article 6 is different from the presumption of legality.
I'll come to that whenever you want.
Well, I need to deal with it now, because the point about Article 6, which is partly why it's different, is that when you approach an Article 6 issue, the right approach is to look at what the statute means, without regard to Article 6, give it its natural and ordinary meaning, and then ask, is it compliant with, and then ask, on the basis, decide whether it's complies with Article 6. So you don't interpret it differently. You interpret it exactly the way you would ordinarily want to interpret something. You then ask whether it's compliant with Article 6, having regard to justification. That's to say, is it proportionate and legitimate? In other words, you're not in the first instance, when you're interpreting, mangling, changing words because of Article 6. You're giving it its ordinary interpretation. The reason you
I
can't...
thought that was what you did under Section 3.
No, you do that at a second stage, and at the second stage, you would only ever do that if you'd first concluded that it wasn't justified. That's to say, proportionate and aimed at a legitimate objective. Okay. Which means that here, let's say we get out of, I mean, I'm spending a lot of time on the presumption of legality. I actually think it's clear that even taking that into account,
Do
it's
take time,
compliant.
because as far as I'm concerned, I'm also interested in Section 3 and
I
Article
understand.
6.
So when you get to Article 6, the way in which the authorities instruct one to proceed is two stages. The first is you give it its natural and ordinary meaning. You look at the statute and you say, what does it mean? At the next stage, you ask, having regard to proportionality and legitimate aim, does this infringe or not infringe Article 6? So you're not interpreting it, you interpret it in the ordinary way, you then test it for justification by having regard to proportionality and legitimate objective, and if it fails that, you can read it down, read it in, interpret it in a particular way. In other words, the interpretation only comes at a point in time where you are satisfied that it's not justified, having got its ordinary meaning. Now that really matters, because here you would have to test that by saying, okay, let's assume that it trammels every right in the world. You're doing this because of sanctions. Sanctions, is that a legitimate objective that you have this? And are you doing it in a proportionate way? Because if you are, we're not going to change anything at all with this legislation. It's going to be exactly as it says it is. We're not reading anything in it, we're not reading anything down, because we interpret it naturally. You ask the important question, is it proportionate, is it legitimate, is it justified? Having regard to the sanctions regime and why you have sanctions against Russia. And even if it trammels a whole lot of rights, including a right of access, if it's justifiable because of sanctions, you don't change it at all. Now, on the right of access, the common law right of access, you never get into the proportionate, legitimate. You are simply reading the language in a particular way. And as Lord Sales says, I'll stop in a minute, as Lord Sales or Philip Sales says in the article he wrote, which I'll take you to, an important difference between the two is that when you're dealing with Article 6, you can read in language. In common law, it's just an interpretation point. You look at the language and you say, well, what does this mean? I'm going to interpret it with, in the back of my head, the idea that Parliament doesn't intend to interfere with your right of access. So they are very, very different. And when I come back to the point that we're on, that this is non-UK legislation, therefore you have to be very careful how you read it. You can't read it with an English perspective on presumptions. That is why I distinguish Article 6, because Article 6 would also not read this would not read it with the way in which you would read it in a purely local common law way. Not least because there's that important stage of, is this proportionate and legitimate? Because if it is, you leave the language alone. So it is very different, and it matters that this is not UK. These
There's
words.
still two ways of reaching the same result.
But importantly, my lord, if we're in Article 6, and I keep saying this, if you get into Article 6, it's pretty clear that because sanctions is generally regarded as a legitimate objective, and restrictions of the sort that you're dealing with here are regarded as proportionate. Sanctions, there is a case called RT France, which has already held this in Europe. Sanctions regime, almost identical to this, found to be completely okay, albeit that there what was being challenged was a right of expression. But basically, the EU law takes the view that given the legitimate objective that you have with sanctions, it's okay to trammel rights. So if we're in Article 6, with respect, this is not going to fall to an Article 6 challenge. Certainly if our law is regarded as the same as European law, and in every respect we're doing exactly the same things as they are. So, as I say, because once you get into the proportionate and legitimate calculation, one is going to leave this alone. Common law right, common law principle of legitimacy, in a sense, attacks this at an earlier stage.
Can I just raise two things? First of which is very likely a red herring, but I think if you look at the recitals to the EU regulation, which I don't think we've got yet, but if I've printed it correctly, I have got one. And recital 6 says the regulation respects the right to an effective remedy and to a fair trial. This regulation should be applied in accordance with those principles and rights. Now, does that suggest that in construing the EU regulation, we don't take the approach that you've been suggesting?
With respect, no. But I think what that is doing is saying you can challenge a designation.
Yes, I see. And then my other question is there a tension between what you're now putting forward and what you were telling us about Article 7.2c? Because your answer to Article 7.2c is to an extent, look, it's not EU law. We look at UK law, and that deliberately hasn't followed the EU law. So why should we care about the fact that there's an EU predecessor?
Yeah, your Lordship is right, there is a potential tension, but your Lordship will have in mind that my primary argument about 7.2c is that the learned judge was wrong to find the implication that she did, and that actually, even under the EU regulation, there is nothing which said you could enter judgment. Your Lordship is right. Once one gets to the, if I'm wrong about that, don't worry about it because Article 11 and Article 7 were thrown away anyway, or 7.2c. There is certainly a tension between that and what I'm saying now. But it is possible to, in a sense, find my way through that by saying they're choosing particular words here. So they may be trying to limit it in a way, make sanctions tighter. But the words that my argument depend upon are plainly the same words.
Well, you can say, I think, legitimately that or a possible ground of distinction is that the point about 7.2c is that the UK legislation doesn't.
It narrows
It
it.
simply deletes it.
It narrows it.
Whereas in relation to the words that we're focusing on, like funds and economic resources, the UK legislation is using the same words as
Exactly.
the EU legislation.
And that is consistent with tightening and narrowing. It's certainly not widening it, widening the rights of the sanctioned person, making it harder for them.
Right.
So I'm not sure I can labour this anymore. I think your Lordships have the points. These words are imported from a non-UK statute, and it would be wrong just to proceed on the basis that, is one saying that the meaning of these words, there was an intention to change the meaning of these words from the way in which they were used, exactly the same words before they were transposed identically? In my respectful submission, the answer is very likely no. Parliament certainly didn't intend that. And if that's right, and that's what the principle of legality would do, then well, the principle of legality simply doesn't arise. So, and effectively what I'm arguing here, or submitting, is really in line with Lord Hoffman's approach in the Peconic case, P-E-C-O-N-I-C. And your lordships have that at tab 64, volume 12 for your lordships, at page 3819. And perhaps I can just invite your lordships to turn it up, although I think your lordships have the point anyway. So tab 64, page 3819.
Sorry,
Tab 64, page 3819.
sorry.
This case was concerned with the construction of section 20 of the Hong Kong Limitation Ordinance. If I can invite your lordships please to go to paragraph 19, which you have at 3826, right at the bottom of the page. And just picking this up, the language of section 20, like most of the ordinance, is taken word for word from the UK Limitation Act 1939. It was obviously intended to have the same meaning. One therefore has to ask whether Danny Lau would have been a constructive trustee within the meaning of the corresponding section of the 39 Act. That's effectively the line, the argument I'm making. And so Lord Hoffman, as your lordship sees, recognised that the Hong Kong legislature, in taking almost word for word the language of the 39 UK legislation, intended to adopt the UK meaning. Now, the learned friends, in responding to this, seek to distinguish Peconic on the basis that the 2018 Act is, as they say, not simply a copy, their words, of the equivalent EU regime. And the learned judge made a similar point at paragraph 98 of the judgment, when she pointed out that the UK regime has been adapted extensively and is not a word-for-word copy of the United Nations and EU regimes. But my lords, well again, that is certainly true, what is said there. What is also true, I would submit, is that the particular words with which we are concerned, namely funds, economic resources, freezing and making available, are virtually identical to the words that had been used in these previous statutes. The fact that some other wording may be different is not a reason, we submit, to infer that this particular wording was intended to mean anything different. And in fact, my lords, it is my learned friend's own case that they do not mean anything different to what they meant under the EU regime. That's their continuation point, or whatever it is. Indeed, they are at pains to emphasise that Parliament did not intend to change the EU law position on the ability to obtain judgments. For example, for your lordship's notes, paragraph 10 and 27 of their skeletons. That's at page 89 and 97. And if that is correct, then the principle of legality must be irrelevant, because the court is in effect being asked to decide what the effect of what the EU meaning of these phrases is. So my lords, that was the third of our four reasons. I'm going to deal with the fourth one shortly. And it is this. This derives from a point made extrajudicially by Mr. Philip Sales, as he was then. It's that the principle of legality does not apply unless Parliament can be said to have been on notice when the legislation was enacted that the fundamental common law right allegedly infringed by the legislation existed. Because if Parliament was not on notice of this, then there can be no basis for a presumption that Parliament would not have intended to restrict that right. And perhaps I can just show this to your lordship, and indeed Lord Sales' article. It is at volume 16 of your lordship's bundles, tab 108, page 4986. it's within internal pages LQR 605. Just picking it up as the fourth paragraph down, beginning as to the first issue. So page 4986.
Yeah.
It's about a quarter of the way down. Your Lordship sees a paragraph beginning as to the first issue. So about 3 or 4 paragraphs down, 3 paragraphs down. As to the first issue, it is submitted that the principle of legality operates within narrow parameters for powerful constitutional reasons, since the effect of the application of the principle is to change what appears to be the natural meaning of a legislative provision. It is only where there is an established, well-recognised and fundamental principle or right, which can be clearly identified as being applicable at the time the legislation is passed, that it can be said that Parliament cannot be taken to have intended to infringe that principle or right by the use of general language in a statutory provision, contrary to the ordinary sense of the words used as a matter of language. But if Parliament cannot be taken to have been squarely on notice of the existence of such a principle or right, then the process of reading down and modifying the natural meaning of words used would undermine rather than promote Parliament's intention as expressed in the language. Now, we should say immediately we accept that the right of access to the courts is a fundamental common right, and that Parliament must have taken to have known about that. The issue really relates to whether Parliament must be taken to have known about the scope of the right of access, and whether, as my learned friends say, it extends to the giving and entry of judgments. I would just note that in the Witham case, I've mentioned this already, Mr. Justice Laws, as he was, talked about that right as being a right to enter the court door. From a learned friend's argument, it has to extend to include a right to obtain justice and indeed a right to do so without undue delay. Not merely a right to commence and pursue proceedings. My Lords, prior to the judgment of the judge in this case, there is no English case of which we are aware, and my learned friends have not cited any, in which a bar on obtaining judgment, still less a temporary bar on obtaining judgment, as distinct from a bar on commencing and pursuing proceedings, has been found to be an infringement of the common law right of access. There has never been a suggestion made in any prior authority. So it was certainly, we submit, not clearly established, bless you, by 2018 that the right of access extends that far. That is to say, it extends as far as to prevent even a temporary delay in the entry of a judgment. And we respectfully submit that it does not extend that far, but whether it does or not, it certainly wasn't clearly established. And if that is right, my Lord, then, as Lord Sales says, one does need to be careful when dealing with the right of access and Parliament's intention to ask oneself whether if Parliament weren't aware of this, they could have had in mind or should have had in mind, or you should assume that they didn't intend to interfere with this. And that really is the short point that we make about that. So, my Lords, that is what we say about why the right of access doesn't arise in the present case, and why your Lordships need not be concerned about the principle of legality. Just why that would matter. If the principle of legality doesn't apply, just getting back to the judgments, there is, we respectfully submit, nothing, even on the learned judge's own analysis, that explains why Regulation 12 in particular is not infringed by the entry of judgment on the causes of action advanced by the claimants. But my Lords, even if your Lordships were to reject all of our 4 points, about the principle of legality, and even if your lordships were to hold that the principle of legality does apply, it of course doesn't automatically follow that our construction of the regulation is wrong. Which is why perhaps I shouldn't have taken as long as I did dealing with this. The question at that stage of the analysis would be, is the restriction on the common law right of access to the courts, which for these purposes includes the right to actually obtain a judgment, something that is clearly authorized by the relevant primary legislation, that is, the 2018 Act? Putting the question this way, my lords, and asking whether this restriction is clearly authorized, is, as I've already noted, how it was put by Lord Reed in the Unison case, which for your lordships note is at tab 77, which is in volume 13, page 4251, at paragraph 79. And as your lordships will know, we submit that this is something that is clearly authorized by the Act. And that follows, my lords, from the fact that the language does not, we say, admit of any other meaning. Certainly nothing that either my learned friends or indeed the judge has even put forward. Because they do not put forward any other meaning. So, for example, if your lordships can just go back to section 3.1d of the 2018 Act, so that's tab 11, which is in volume 3 for your lordships, page 771. It's looking at 3.1d. For purposes of section 1.5a regulations, impose financial sanctions if they impose prohibitions or requirements for one of the following purposes.
Sorry, which section?
3.1d. Preventing funds or economic resources from being made available to or for the benefit of designated persons. And that, as your lordship will recall, is reflected in Regulation 12.1 of the 29 regulations, which states that for the period while sanctions are in place, no persons may make funds available to a designated person. Your lordships already have my submission that there is no possible construction of the court of those words which would permit the court to read it as if it said, no person shall make funds available to a designated person, and then these words read in, save that a judgment debt may be made available to a designated person. No possible reading which would allow you to do that. That would involve rewriting the 2018 Act and the 2019 regulations. And as I submitted to your lordship by reference to Lord Phillips in Ahmed, the principle of legality does not permit or require the court to do that. In the LQR article, which I showed your lordships, Lord Sales also made the point that while the principle of legality allows the court to read general or broad wording restrictively, it doesn't allow the court to read additional wording into the legislation. Reading in, as opposed to reading down, is, we would respectfully submit, the only way to arrive at the construction of Regulation 12, adopted by the judge, by the learned judge. For your lordship's note, the distinction Lord Sales draws between reading down and reading in is at tab 108, page 4988. Again, that was in bundle 16 for your lordships. Internal pages 610 and 611. Yeah, perhaps I can just show that to your lordship. So tab 60, bundle 16, tab 108, 4988.
which page did you
Page
say?
4988.
Oh, I see, I see. Yeah.
Yeah.
And your lordship see the heading, comparison of the application of the principles of legality and section 3 of the Human Rights Act. And I was just going to pick up the third point that he makes there. Thirdly, and related to the points above, section 3 of the Human Rights Act, by analogy with the mar-leasing principle in EU law, requires and authorises a more wide-ranging approach to reading in language to a statute, as distinct from reading down. That is because section 3 of the HRA requires legislation to be measured against a clear external body of law with its own determinate content and made to conform, if possible, to that law. By contrast, while reading down of general language is the usual interpretive technique employed when the principle of legality applies, it is more difficult to justify reading in additional words under that principle. That is because within the Constitution as it is developed based on the sovereignty of Parliament, legislative intent is to be taken to be derived from the actual language used by Parliament, and for a court to read in additional words to extend the application of a statute, as distinct from modifying its application within the ostensible field of application by reading down, will usually appear to conflict with the limited interpretive role which the courts enjoy outside the EU and HRA contexts. Partly for this reason, and partly because in the sphere of individual rights it is likely that the courts will take the expression given to them by the HRA as having a particular democratic parliamentary authority, and partly in the interest of simplifying and giving clear structure to the legal examination of the meaning of statutes, it seems likely that analysis under section 3 of the HRA will to a considerable extent now eclipse reasoning based on the principle of legality. It's perhaps significant that the heyday of the application of the principle of legality in relation to individual human rights was in the period just before the coming into force of the HRA, and that the leading cases, in particular Sims and Witham, both made express reference to convention rights as sources to provide determinate content for what were identified as domestic constitutional rights for individuals. But in the wider context for application of the principle of legality, outside individual rights, the principle remains an important guide to the meaning which Parliament has taken to the intended legislation to bear. So I think I may have read more than I needed to, but your lordship see the point about distinction between reading in and reading down. Now, just on this point, I've already made the point to your lordships that the learned judge held that a judgment debt constitutes funds, and the learned judge held that a cause of action constitutes economic resources. And my lords, even with recourse to the principle of legality, we respectfully submit that there is no possible construction of the words funds and economic resources that could exclude judgment debts and causes of action respectively. And we would also submit that the definition of dealing and making available in particular are at least as clear as the definition of funds and economic resources. And I say that in particular with the making available. And my lords, if the principle of legality did not prevent the judge from treating judgment debts and causes of action as funds and economic resources, we respectfully submit that it is not at all easy to see why it prevented her from treating the entry of a judgment as making funds available, or indeed as a dealing in those funds and economic resources. Certainly there is no explanation given. Now, I think that is all I was going to say about right of access, common law principle of legality. Now, I need to move on to Article 6. I don't know whether your lordships...
Well, I think it's probably sensible if we rise now then. How are you doing, Mr.
I'm doing just about okay. I may have to speed up at some bits, but in a sense we've gone through the...
You tried not to interrupt you
No,
too much.
it's not your fault at all. It's my fault if I've gone slowly. I may have to speed up on some things too.
Good. All right, well, 10:30 tomorrow morning then. Thank you.